Converting a state into union territory is a lack of source of power that doesn't exist in the constitution. It can't be done. But, subject to what Justice Kaul said yesterday, can you take a part of a state and convert it into union territory? Yes, you can. Article 3 provides for it, but there is a procedure for exercise of that power. That procedure has not been followed. Lordships would see from 379 onwards. Fortunately, this book is there now. They've all been repealed, 379 to 390. Those were also pro tem provisions dealing with the provisional parliament. In fact, the converse of the converse of what was shown to your lordships earlier about the explanation provided in Jammu and Kashmir of where the Constituent Assembly of Jammu and Kashmir would conduct itself as the legislative assembly. The identical provision is Article 379, which stands repealed, which is that the Constituent Assembly of India would be the provisional parliament and they would elect the President of India for the time being, etc. Now, those are pro tem provisions. I'll show your lordships that in detail. But on this point, the question I ask myself is, 370 clause 3 provides, and those opening words are very important, notwithstanding anything in the foregoing provisions of this article. Now, that I think segues exactly with what my Lord the Chief Justice said. Wouldn't this be surplusage? What was the need for these words? The need, in my view, for these words, because what is it in the provisions above that are standing in the way of 370 clause 3? It appears that 370 clause 1 has excluded the possibility of Article 1 and Article 370. 238 anyway had gone by that. Of these two provisions being in any way the subject matter of orders under 370 clause 1 subclause D. It had excluded it. What 370 clause 3, and I have to look at it keeping two things in mind. 2023, when I'm making this argument, and the fact that Sampath Prakash as well as your lordships have held that this position of 371D being operationalized is the position, that's a correct position, there's no way of questioning it. If I keep those two parameters in mind, the Constituent Assembly sitting in 1952 is faced with the choice which is provided under 370 clause 3, which is that notwithstanding anything in the provisions above, you have to decide whether you want to keep 370 alive in some form with exceptions or modifications, or do you want to junk it as a whole? Now, if they were to take that other choice, and we are grateful that they didn't, but if it was a question of doing so, what is the impact on the Article 1 not being made applicable? What is the impact on it? The way I see it, the impact is, and it's an unfortunate answer, the impact is that Article 1 wouldn't apply to them if they had decided so. And it in my view, that's the danger of recreating a Constituent Assembly at any point. Article 368 in our Constitution doesn't permit repeal of the Constitution. Please see. It says amend, modify, repeal any provision of the Constitution, not the Constitution itself. And after the basic structure has come, there's no question of that. Now, what is our fear with this Constituent Assembly argument? It would be very difficult for this court to give a verdict on the Constituent Assembly being resurrected as far as the state of Kashmir is concerned, and in a future date tell us that no, that's a principle that applies to Kashmir, it doesn't apply to the Constituent Assembly of India. My view is it applies squarely to the Constituent Assembly of India. There is no question of suddenly reviving or resurrecting the Constituent Assembly of India in any fashion. It's done for. What you want to do, you do by amending this constitution. This is something we and our forebears have tied ourselves down to. That's the idea behind the basic structure. There is no way of incremental modifications being made by virtue of resurrecting constituent assemblies. This case is effectively about, one, whether a power exists, and two, has the procedure laid down for the exercise of that power been followed. In Article 3, for example, there's a question that Justice Kaul put to Mr. Chandrachud Singh yesterday. Converting a state into union territory is a lack of source of power that doesn't exist in the constitution. It can't be done. But, subject to what Justice Kaul said yesterday, can you take a part of a state and convert it into union territory? Yes, you can. Article 3 provides for it, but there is a procedure for exercise of that power. That procedure has not been followed. I hope I'm making myself clear. So there's a source of power, whether it exists or not, and then there is the exercise of that power. The same argument applies to Article 370. Does the prospect of creating a constituent assembly exist today vis-a-vis Kashmir or vis-a-vis India? No. My answer is a square no. That's not provided for in the constitution, therefore it doesn't exist. In any event, and without prejudice to that argument, the exercise of the power and the manner of exercise of that power is one of the most fraudulent, invidious exercises that we have seen in this country since 1970. And why do I say 1970? In 1970, when they wanted to get rid of the privy purses, they moved a constituent assembly bill, amendment bill. That bill went to the Lok Sabha and passed through the Lok Sabha. It went to the Rajya Sabha and it was defeated by one vote. One vote. And then what did they do? Overnight, the president issues an order under Article 366, definition provision of the rulers, and uses that power to say from tomorrow onwards, there are no rulers, all your privy purses. What have they done differently today? They just use the next provision. They use 367. And your lordships came down like a ton of bricks on them. 9:2 you held against that kind of an action. And I want to show your lordships Madhavrao Sinha because I believe it squarely applies. They finally had to go back to the drawing board. They had to come with a constitutional amendment. That constitutional amendment was sustained in Raghunath Rao Ganpat Rao 20 years later. But the fact is, following procedures laid down in the constitution are sanctified mechanisms which protect us, which protect this constitution. The sovereignty doesn't go to the executive. The executive is a creature of the constitution, as is this court. The people are the sovereigns under our constitution. Let there be no doubt about that. Because I believe that there is some feeling, which is the same feeling that the government had at the time of Madhavrao Sinha, that some level of paramountcy, some level of sovereignty had devolved on the executive. So an executive has some residue power by which they will interpret the constitution differently. They will use definition clauses where they can't touch it directly. My Lord Justice Khanna on day one was considering the proviso to Article 370 and said, look, that's a proviso. But the proviso is perhaps the most important thing in this constitution. Constitution amendments in this country have been struck down on only two grounds. Only two. One was basic structure. The other was a proviso. The proviso in 368(2) was the reason why in Quixote Holohan, para 7 was struck down. Again, the amendments that were brought in for cooperative societies, your lordship struck down because it didn't meet with 368(2). I remember, my lord, the Chief Justice mentioning on day one about 368(2) proviso. Can you use that by way of the 356 route? I think that's a fantastic question. That's the heart of this case. Can you do that? Can you use 367? Can you use 366? Can you go sideways? The proviso provides the procedure you will follow. And you, creature and servant of the constitution, will use no other procedure. We are not sitting here in deference to our equals. Our elected representatives have taken a choice. They've made a choice that they will follow the constitution. Their oaths bind them to it. And they decide to follow devices like this. And they possibly don't learn from the lessons of the past. And I want to show your lordship the language of Justice Hidayatullah, Justice Shah in majority, Justice Hegde concurring in Madhavrao. It completely, in my view, covers this case fully. It's the exact same thing. In fact, it's less complicated, less experimental.